This is a California regulatory explainer on OAL's 6 standards of review of proposed regulations. Now, California's OAL, the Office of Administrative Law, plays several roles concerning the rulemaking activities of the state's over 200 regulatory agencies, departments, boards, and commissions. There's not just the regular rulemaking, but also emergency rulemaking and even review of alleged underground regulations is all done by OAL. Now, most agencies in the state and the executive branch of state government enjoy broad grants of rulemaking authority by statute. In some instances, the legislature has provided a limited grant of authority in order to adopt regulations. Most of these 200 regulatory entities have adopted regulations, and OAL reviews anywhere from 5 to 600 regulations per year. Now, when OAL reviews regulations, its review is dictated by California's Administrative Procedure Act, or the APA, which of course is found in California's government code. The APA sets forth 6 standards in statute by which OAL determines whether a proposed regulation was properly adopted, meaning that it followed all of the procedural requirements set forth in the APA. Those 6 standards are defined in the California Government Code, and there have been numerous court decisions interpreting all 6 standards that provide further guidance. So, what are these standards? The first two are authority and reference standards. The authority standard is basically reviewing whether the proposed regulation states the provision of law which authorizes or requires the proposed regulatory action. The reference standard is basically reviewing whether the proposed regulation cites the applicable law which is being implemented, interpreted, or made specific by the proposed rulemaking. Now, according to OAL, complying with the authority and reference standards involves a rulemaking agency doing 2 activities. First, picking the appropriate authority and reference citations for the note that follows each regulatory section that's printed in the California Code of Regulations, as well as adopting a regulation that is within the scope of the rulemaking power that's conferred upon that agency or department. Now, by law, each regulation section that's printed in the California Code of Regulations, the CCR, must have a citation to the specific statutory authority under which it was enacted, and a citation to the specific statute or other provision of law that the regulation is implementing, interpreting, or making specific. If the underlying statute does not expressly or impliedly provide authority for the proposed regulation, then it is void. The next standard is the consistency standard. And this standard is basically reviewing whether the proposed regulation is in harmony with and not in conflict with other laws. In this regard, the review by OAL focuses on whether the proposed regulation is consistent with the underlying statute. According to OAL, consistency is viewed as whether the regulation is reasonably designed to aid a statutory objective, that it doesn't conflict with or contradict or even alter, amend, enlarge, or restrict any applicable statutory provision. The next statutory standard of review is the clarity standard. This standard is basically reviewing whether the proposed regulation is easily understood by those who are affected by it. According to OAL, regulations are frequently unclear and unnecessarily complex, even when the technical nature of the subject matter is taken into account. They are often confusing for some of the persons who must comply with them. The intent of this statutory standard of review is to ensure that the rulemaking agency drafts its regulation text in plain, straightforward language, where they try to avoid technical terms as much as possible using coherent and easily readable language. In this regard, OAL attempts to ensure that each regulation can be easily understood by those who are regulated and avoid instances where a regulation is unclear to the regulated community. The fifth standard is the non-duplication standard. This standard is basically reviewing whether the proposed regulation does not serve the same purpose as any other state law or regulation. Here, OAL explains that a regulation cannot simply repeat or rephrase a statute. In other words, a regulation cannot serve the same purpose as that of an existing statute or another regulation. If it does, then there must be some justification to doing so. The final standard is necessity, and this standard is basically reviewing whether the need for the proposed regulation has been demonstrated by substantial evidence. Here, the rulemaking entity must have a complete rulemaking file when it submits the final work product to OAL. The rulemaking file must include all materials and background upon which the proposed regulation is based. The initial and the final statements of reasons, called the ISOR and the FSOR, must be thorough to explain why the provision is reasonably necessary to accomplish the stated purpose. Also, the rulemaking file must identify and include in the record any materials that were relied upon in proposing the provision and any other information, statement, report, or data that the agency is required by law to consider or prepare in connection with that rulemaking action. Finally, OAL is limited in its review of the record of rulemaking proceedings as well as the rulemaking file itself. In addition, a court reviewing the regulation will be limited to the documents contained in that rulemaking record. As such, it's important for the rulemaking agency to comply with all the requirements of the APA to ensure that their rulemaking file is complete.